Being here. We'll just give folks another moment to join us from the waiting room. We have about 50 participants and more streaming in. All right. Well, welcome to Under the Microscope, the cases targeting America's scientists, scholars, and researchers in 2026. My name is Gisela Kusakawa, and I'm the Executive Director of the Asian American Scholar Forum. I'm an attorney by training, and over the course of my career, I've worked at the intersection of anti-discrimination, criminal and immigration law, national and research security, and the protection of civil rights. Much of it alongside the very researchers this conversation is about. It's an honor to be a moderator today with our fantastic panelists. Now, let me say a few words about who AASF is. The Asian American Scholar Forum, AASF, is a nonprofit dedicated to protecting the rights, freedom, and well-being of Asian American scholars, scientists, and researchers. We were founded in the shadow of the China Initiative, a time when researchers across the country suddenly found themselves under federal investigation and far too often presumed guilt. Our ASF fellows came together, many prominent leaders from the National Academies of Engineering, Medicine, and Science, and the American Academy of Arts and Sciences, as well as past and current university presidents, provosts, vice provosts, deans, associate deans, and department chairs, and recipients of prestigious awards and honors. To accomplish our mission, which is to safeguard freedom, to defend against racial profiling and discrimination, and to ensure that the scientists, researchers, and scholars who power American innovation can do their work without fear. We advocate, we educate, and we connect this community with the resources and the legal support that they need. Today's webinar is part of that mission to give you a clear-eyed picture of the legal landscape straight from the attorneys who are on the front lines. Now, a few quick housekeeping notes before we begin. First, today's session is being recorded and we'll share that recording with everyone who registered. Second, we want to hear from you. Please use the Q&A box at the bottom of your screen to submit questions at any time during the programming. Many of you already submitted questions when you registered, nearly 20, and we'll get to as many as we can in the final part of today's sessions. To our panelists, please keep yourselves muted when you're not speaking and keep your cameras on so our audience can see you. Now, one important note, today's conversation is for informational and educational purposes only. Nothing our speakers share constitutes legal advice, and joining us today does not create an attorney-client relationship. If you are facing a legal issue, please consult an attorney about your specific situation. So why are we here today? Scientists, scholars, and researchers are facing a level of scrutiny that many of us have not seen in our lifetimes: federal investigations, criminal charges, visa threats, wrongful terminations, and administrative leave and consequences. These cases stretch across universities, research institutions, and industries well beyond STEM, and the consequences reach far beyond any one individual. They touch the entire research community and the principle of freedom itself. We've assembled an extraordinary panel of attorneys who are on the front lines of these cases. Here's how today will work. Each of our speakers will take about 10 minutes to introduce themselves and share what they're seeing on the ground. After that, I'll put a few questions directly to them and we'll open the floor to all of you. So let's go ahead and introduce our panel and dive right in with our first two speakers, who both come from Nixon Peabody. Ron Fisher is a Chambers-ranked trial attorney and former federal prosecutor with more than 25 years in government investigation and white-collar matters. In recent years, Rob has defended some of the nation's most prominent scientists and researchers, including Dr. Gang Chen, in China Initiative cases. His work has been featured on 60 Minutes, in Netflix documentaries, and across the Wall Street Journal, the New York Times, and the Washington Post. He's joined by his colleague, John Sandweg, who leads Nixon Peabody's cross-border risk teams. John's work centers on national security, immigration, and DHS compliance. Before private practice, John served as the acting director of U.S. Immigration and Customs Enforcement, overseeing roughly 20,000 employees worldwide, and as the acting general counsel of the Department of Homeland Security, its chief legal counsel. He's a frequent voice on immigration and border enforcement for CNN, NPR, and PBS. So, Rob and John, I'll hand it over to the two of you to get us started. As you introduce yourselves, I'd love for you to share your perspective on the current legal landscape, the kinds of cases that you're seeing on the ground, whether you're noticing that upward trend in volume, and what resources you believe researchers have when they need legal recourse. Thank you. Over to you.
Thanks, Gazella. John, I'll start for a few minutes and then turn it over to you.
Sounds good.
As Gazella said, I've been doing this work for about 6 or 7 years. One of the first matters I worked on was the indictment of Gang Chen, the former head of mechanical engineering at MIT. And since then, I've represented between 60 and 70 scientists, researchers, even CEOs of companies that are China-based or have connections to China. And essentially, I know that a lot of the press, once we got Gang Chen's matter dismissed, said that the China initiative was winding down and it was over. It really wasn't, right? They stopped using that name, that nomenclature at DOJ, calling the investigations they were doing into companies or individuals or scientists that were linked to China. They stopped using the term China initiative during those investigations. But in my practice, I've seen a continuation of those investigations following to the end of the first Trump administration, through the Biden administration, and now into the second Trump administration. I think now we're clearly in an era of China Initiative 2.0. I'm seeing a large uptick in investigations into researchers, scientists, professors who are linked to China or who have postdocs who are back in China and who have government grants. The federal government, the Office of Inspector General at NASA, at DOE, at really all the federal agencies are starting investigations, wanting to speak to professors who have government grants and may have collaborated with China or are currently collaborating with China. So I'm clearly seeing a continuation of these investigations. What we're not seeing yet, though, and John can speak to this, and I think Brian, folks of us who are former federal prosecutors and frequently represent people who are indicted by DOJ or under investigation by DOJ, I'm not seeing the continuation of the investigations turn into indictments yet. I have many folks who are under investigation, whether a search warrant was executed on their home or they've been stopped at the border. They're flying back from China or France or you name it, and they're stopped at the border, they're questioned, their devices are taken, and then they're either turned back around and sent back to their home country, or they're allowed to come in if they're U.S. citizens. Of course, that's a subject John will be able to speak to in depth. But then they'll reach out to someone like myself and say, hey, I want to retain you. I was stopped at the border. I was asked questions. The government took my devices. I don't have them back yet. And that is a telltale sign. That's clearly a red flag that either you or somebody close to you is under investigation, or potentially your company or university is under investigation. Over the past 6 or 7 years, not only have I represented many scientists and professors, but also universities and colleges. And in fact, I was retained by a very large university system yesterday. Only 3 weeks ago on the East Coast, I was in a very long meeting with the FBI and NASA OIG for another institution that's under the microscope, to use a word in the title of this presentation. So there clearly has been a ramp up in the past probably year or so under the new Trump administration. But under no circumstances was there not this type of investigation going on during the Biden administration. I was still getting many phone calls from academics, professors who were stopped at the airport, stopped at the border, their devices were taken, or they got a knock on their door from the FBI or one of the OIGs, the Office of Inspector General. Like I said, for many of the agencies that back these grants that professors in universities will apply for. And what I think a lot of folks didn't understand until China Initiative number one, but there's still a learning curve happening, is how important it is to be completely truthful and report all your foreign collaboration in your grant forms. Now, I know a lot of the universities and colleges have gotten a lot better over the past few years in really building robust compliance systems so that they have lawyers and compliance professionals at the university so that when these professors and scientists are filling out grant forms, they're putting everything they need to down. There are individuals at the institution to understand what needs to be reported, how it needs to be reported, so there's no confusion in terms of what information you're putting down on those forms, so that years later you don't have the accusation that there was some material misrepresentation on the forms, and then you're questioned about it, and things become worse from there. I've also I know there was a question about Charlie Lieber and whether there have been other academics or professors that have been not only indicted but convicted. There have been others. It's public knowledge. I represent Charlie Lieber now. I did not represent him when he was under indictment. It was convicted, but he has been a client of mine since then. And listen, that he is one of the folks who was convicted, unfortunately. Like I tell a lot of people that reach out to me, when you're engaging with the FBI or an investigator for any federal agency about one of your grants or really any collaboration or work you've done in the past, you really need to consult counsel. That is something that gets many researchers and professors and scientists and even government officials in trouble. I worked in the Lieutenant General Flynn investigation years ago, and he was somebody who John knows was national security advisor under Trump one. He was interviewed by the FBI and didn't get a lawyer. He's somebody who should have known, anytime you speak to the FBI or a government agency, you cannot lie to them. You can be indicted as a felon if you do lie. And so many people misunderstand that. Even people high up in government misunderstand it or don't appreciate it enough to make sure they get counsel. So, one thing I want folks to take away from this seminar is when you are approached by the government or even your own university and ask questions about a grant or something that involves collaboration with a foreign country, it is important to consult legal counsel. I know a lot of folks think, well, that may demonstrate that I'm concerned about what I did, or that may be viewed as defensive. It really isn't. In the United States now, almost everybody lawyers up right away. It's really smart to get that type of advice, particularly in the climate we're in now. There are so many issues that you may be asked about that you may not appreciate could be very important, including, if you have any foreign bank accounts, who you're actively collaborating with, what that collaboration means, your visits to foreign countries, any seminars or conferences you went to, who you may have been approached by. So there are so many different areas of questioning now, I find, that the government is very interested in. There's a lot of exposure from folks just sitting down and providing information unless they truly understand the potential consequences of cooperating with law enforcement without a lawyer. So to recap my first part of this 20 minutes that John and I are sharing, I have seen a large uptick in investigations. Again, none of my clients have been charged, knock on wood, yet. I think the last client I had that was indicted was G.K. Chang for a federal matter in Atlanta for collaboration with ZTE. He was indicted. We got those charges dismissed also for multiple different reasons. But again, he was somebody who had been under investigation like Gang Chen for a pretty long time before he was eventually indicted. And what really helped him a lot was getting good legal advice during the investigation, which allowed us to get a good result once the government decided to charge him, and that we were able to get those charges dismissed. and he's now back, I believe, teaching. So we got a really great result there. I'm seeing the same uptick in investigations, really hoping that we can get people the advice and the guidance they need early on so that they don't end up being charged by DOJ or any other law enforcement agency. So that's my 2 cents. Now I'm going to turn it over to John to talk about some of the things he's seeing in the cross-border world, particularly with foreign travel. That is a question I get a lot. Folks will reach out to me and say, Rob, I'm traveling either to China and back, or I'm traveling to wherever it is, Canada, France, London, and what should I be aware of when I'm coming back into the country at the border, since so many folks are being questioned at secondary and are having their devices taken. So that is, I know, a hot topic for many researchers and scientists now. And with that, I'll turn it over to my colleague, John.
Yeah, thanks, Rob. Thanks everyone for having me on. Thanks, Casella, for having us on. So very quickly, let me give a quick 2 cents about my background. As Casella mentioned, I spent 5 years at the U.S. Department of Homeland Security. My primary two jobs there was the acting general counsel of the department and also then the acting director of ICE from 2013 to 2014. But also throughout that time, I served as a senior counselor to the secretary, kind of overseeing all of the U.S. border security, including CBP operations at airports. And while there's a lot of ground to cover with immigration, and obviously immigration has been a real focal point of this administration, let me just zero in, I think, what probably be most relevant to this group, which is international travel and return from international travel. Now, look, obviously, it's always a bit of a harrowing experience to go through CBP inspection. Even under a Biden administration, right? There's always enhanced scrutiny and these enhanced authorities that CBP has. But what we've really seen is a real uptick in the use of those additional authorities that DHS has, through the Immigration Act and other statutes and other kind of inherent authorities that they have. We've seen them being used like we've never seen, we haven't seen in more recent history, with a real emphasis, especially on Chinese population. So what are the risks? I guess the first question, as everyone knows here, the biggest risk is you end up in secondary, and then from there, CBP makes a decision about whether or not they're going to admit you into the United States. I guess the first question most people will ask is why? Why does this happen? As Rob indicated a moment ago, traditionally, when you see this, the first suspicion is criminal investigation, right? And obviously, CBP, Customs and Border Protection, works very closely with all the federal law enforcement agencies. It is not uncommon for an agency that is conducting a criminal investigation to put what's called a lookout. Ask CBP to say, hey, let us know when that individual is traveling to the United States. Those lookouts can either be what's called a silent lookout, saying just let us know if they're traveling. We just want to track that for our awareness. We'll make a decision about whether we want to do something about it. Or a lookout where they have some specific instructions for CBP, asking them to pull them in, question them about certain topics, or pull their electronic devices. But I think one thing people don't realize, and one thing that's happening now, is that there are a lot of these, quote unquote, we'll call them investigations or secondary inspections, that are happening because CBP wants to do this, that CBP has flagged the individual themselves. And I think what people don't realize is how massive CBP has become. Billions and billions of dollars Congress has given them, and where they have built some very expansive tools, so what they call the National Targeting Center, to vet individuals who are traveling to the U.S. and make their own decisions about whether they're going to stop that person, whether they're going to let that person into the United States. As you can imagine, CBP is using a lot of more new sophisticated technologies, a lot of AI to kind of conduct this advanced vetting, and working closely with companies like Palantir to do this vetting. So what happens is, as everyone here may know, when you buy a ticket to fly to the United States, the airline is sharing the manifest with CBP. They're required to share it in advance of departure. At that point, CBP's mechanism starts scrubbing the names and looking, is there any reason why we want to stop this individual? At that point, a decision oftentimes is made from this targeting center to flag the individual or the person as they return in the US. You get up to the booth, you present the facial recognition clicks, they say, okay, you need to go to secondary, they refer you to secondary. Once in secondary, of course, you have very limited rights. And so, as Rob was alluding to earlier, the CBP and DHS has long enjoyed what they call border search authority. So in a normal criminal investigation in the United States, of course, before the US government can get into your phone or read the contents of your text messages or your emails, they require a search warrant, based on probable cause issued by a federal court. In the border environment, though, the court has long held that DHS has the authority to inspect, just like they can inspect your baggage, they can inspect your phones and your electronic devices. And at that point, CBP does not require a warrant and does not even require, they're not required to articulate any suspicion or have any real reason for wanting to do this. More importantly, the courts have held that CBP can image these phones, these devices, take it to a computer lab or take the device itself to a computer lab off-site, pull down the information and hold the information for long periods of time in order to use it for other investigations. This is sweeping authority. We have seen an uptick in the Trump administration of the use of this authority. Now, of course, you as a traveler who are maybe traveling to the United States, this raises a question for you. Do I want to travel with information loaded onto my phone or loaded in my laptop that the US government may be able to search? It's a difficult question for a lawyer like us to answer, because on one hand, you might have confidential information in there, you might have intellectual property that is very sensitive, and that there are good reasons, not that you're trying to hide anything from the government, but there are good reasons why you don't want the government to be able to search that device. On the other hand, if you come through and this phone is empty, it increases the likelihood that CBP may not let you into the United States, right? It might further their suspicion. But I guess that goes to the second question, is what's going to happen as you come through that port? What could happen to you? Every case is different, and the reason why CBP has stopped someone is different in every case. But what we are seeing a lot of in the Trump administration is that rather than pulling people aside solely because it's a criminal investigation, we're seeing a real commitment to pulling people aside in an effort to keep people out of the United States, right? It's not so much that we intend to take your device or pull you into secondary because we want to criminally prosecute you down the line or there's a criminal investigation, but rather now CBP themselves has decided they think that you do not meet the criteria of this administration to be able to enter the US on a visa for whatever reason that is. Seeing a lot more of those kind of circumstances happening. So what are your rights? Well, first of all, unfortunately, you don't have many. If you're traveling on a visa, anything less than a green card, an H-1B, or you're, obviously if you're on a B-1, B-2 especially, but any sort of visa, an L visa, whatever that may be, CBP has an absolute right to cancel the visa right then and there at the port of entry and deport you from the United States. And unfortunately, we're seeing quite a bit of that where someone travels in, has no negative immigration history, has a valid visa, and CBP, for reasons that they don't necessarily articulate, cancels the visa, orders you deported, and sends you out on the next plane back to your home country. In those circumstances, we can talk about this later, but it can be very difficult to come back. There are legal prohibitions that apply when you are formally deported from the United States that can prevent you from getting a new visa entirely. But so why? Why is CBP doing this? Again, there is a real focus, especially on Chinese connections and relations, where I think CBP would argue that they are preventing individuals who pose a national security threat from entering the United States. The challenge, of course, is, as I indicated a moment ago, they're not doing this based on any real, in many cases, in my experience, it's not based on a considered analysis. It's not as if there has been a lot of kind of thought or a real, consultation with other federal agencies that might be involved in national security, but rather this individualized CBP officers are making that determination based on what the AI is saying are potential links to China or travel patterns, or just the fact that it's a Chinese national who's working at a university. That alone is triggering tremendous amounts of scrutiny coming in. Rob mentioned something that's important. All right, what happens if a law enforcement officer wants to interview me? Now I'm in the port of entry. Again, although you're in an environment where you have reduced rights, you do not need to answer questions necessarily of a federal law enforcement officer. But this is tricky as well, because again, typically the CBP officer is going to ask you a number of questions that are ostensibly designed to determine whether or not they are going to let you enter the US, right? Those questions: where were you going? What do you do for a living? What were you doing in China? How long were you gone? Where else did you go while you were abroad? Now, mind you, again, because of information sharing that DHS has around the world, they often know the answers to a lot of those questions. They know where you've been, they know when you've flown. But those are questions that are designed to determine what in immigration law would be called your admissibility, your ability to enter the United States. Of course, those questions are also designed to will be fed to other agencies and are available going forward and could be used to further an investigation. And so the question becomes, at what point do you say, hey, I don't want to answer any more questions because I'm worried that this is all actually designed to further some sort of criminal investigation against me? And that's difficult to say, because if you decide you're not going to answer additional questions, of course, it dramatically increases the likelihood that CBP is not going to let you into the United States. I will say this so quickly. A big tell is that there are plenty of cases, not always, but a big question that Rob will ask or I'll ask when someone calls me, saying this happened to them, is who came to the port of entry and interviewed you? Was it a CBP officer wearing that traditional blue CBP uniform, or was it from another federal agency? Was it FBI? Was it Homeland Security, ICE, HSI? And that can make a big difference in terms of giving us clues about whether or not this is part of a criminal investigation or is more of an immigration kind of under this bolstered DHS, more aggressive approach that we're seeing. I will say another thing. You do retain your Fifth Amendment right to remain silent or to request counsel while you're subject to that port of entry questioning. CBP will not recognize that, will not give access to a lawyer. They may or may not let you call a lawyer while you're in there, but you have not given up your right to remain silent and or to ask to speak to counsel while you're in the port of entry. My only caveat again is it does increase the likelihood that CBP is going to churn you around, potentially cancel your visa and deport you. Final thing I'll say, and I've covered a lot of ground, but as Rob indicated, I do think the best thing you should do is consult with counsel before you travel. At the end of the day, the simple, sad reality is that anytime a visa holder travels internationally, they are at great risk. And the effort, in immigration law, 80% of it is on where you're located. It is actually, despite everything we're seeing on the news and on TV right now, it remains challenging for ICE in the United States to deport someone who's legally present on a visa. It would be a challenge for them to say this professor is somehow a national security threat. They would have to prove that in a court of law in the United States in order to deport you. However, when you travel, all of that goes out the window. You have there's no obligation on the government to prove any sort of threat or really offer any basis at all to cancel your visa. So there's tremendous risk when you travel. And I think that's just one thing that people have to accept in this time frame, is that if I travel and if there's something the government doesn't like about me, I am essentially powerless to challenge the government when I'm in that port of entry. Or sometimes it even happens before you board the plane. They give direction to the airline, don't board this individual. We've canceled their visa. But again, should you have to travel, it's probably my strongest advice, though, is to consult with counsel about the risks of traveling and how you should approach things like the data that's on your phone, the data in your computer, and how you should approach things like, should you get questioned, and what to do if you're questioned. Happy to chat more about all this as we go forward, and I don't want to just take too much time right now, Gisela, so if we want to hand it over to the next speaker.
Thank you so much, John and Rob. And actually, while we're on the topic of international travel, if I could just ask you both questions that are quite common that we received both for this webinar and beforehand. But John and Rob, when we think about our researchers right now who have to decide whether to get on a plane, whether it's to present at a conference or simply to visit family, how should they assess that risk internally for themselves? And does having even university approved travel offer any level of protection for our researchers? We often get questions from our professors saying, well, we have this letter from our university, so the travel should be fine, right? And Rob, from the defense side, oftentimes we get this question, if I am stopped, does this mean that I am definitely under criminal investigation? When does that line cross? When is that line crossed? And how do people know whether they need an immigration and a criminal defense attorney? So just to you
yeah, because let me take the first one quickly, Rob, and I'll hand over to you. First of all, to answer the last question, though, they should, Rob and I are always available as a team, so it works out well. But in all seriousness, look, travel right now is very risky. Okay, there are cases where we have certain clients in certain cases where we can make contact with, in certain cases, I can make contact with CBP in advance and at least try to assuage any concerns on the front end. That is certainly not always the case, but there are circumstances where that can be done. If you have the backing of your university, there's a political element to this, as with everything, especially right now in the U.S., there's a political element to this. There are things that the university can do to help pave the way and try to prevent problems on the front end. And certainly I would recommend, that you contact a lawyer before you travel to do everything that is possible to try to minimize the risks before you even go. But I will just say this, at the end of the day, the challenge is as follows, is that the legal rights of a visa holder, a non-immigrant visa holder, whether, like I said, whether that's H-1B or really anything short of a green card, are incredibly limited. And that's individual CBP officer at the port of entry has the absolute right to cancel the visa, issue you a expedited removal order right then and there, deporting you from the United States and putting you on the next plane back after they take your phones and after they search your luggage. And so that is always the risk. And even though there are things that can be done in advance, and even though there are things the university can do to mitigate those risks, the reality too is I would say that these decisions are made by CBP. If look, when I was at a high level at DHS, I get calls all the time from the White House or a congressman. Why did you deny Rob entry into the United States? And I reach out to CBP and say, hey guys, what's going on with this case? Why did we do this? They'll come back to me and they'll say it's national security. We think he's a link to Chinese intelligence or something like that. The point is that politically, that's kryptonite for the politicians, right? I reach back out to the congressman's office or the senator's office. I say, hey, it's national security concerns, intelligence concerns. They back, thank you, we're out, back off right away. And that's, I guess what I'm trying to say is that there's cover for it, if that makes sense. And no one digs into what is the basis of this concern or how strong is the link. But in any event, the point of my story is there are risks. There's some things you can do to mitigate those on the front end. There's things you can do to manage them. But at the end of the day, you're taking a substantial risk, and it's a decision you just need to kind of make, recognizing that if the government wants to kick you out and you're in the US, it's very hard for the government. But if you're outside, it's very easy.
Yeah, Gisela, to get to the university point, so what I tell my clients is you want to make sure you are in compliance with your university guidelines. So yeah, if you work for, Harvard, just to pull out of the hat, you want to make sure you tell them, hey, I'm traveling over to Beijing, I'm going to this conference. What can I bring? Can I bring my university laptop? Oftentimes, now colleges and universities and companies are saying, no, you can't bring your work laptop. You have to bring a loaner. You can't bring your work phone. You have to bring a loaner. And that leads me into something that John had mentioned. Yeah, it is a risk if you hit the border and you have a completely wiped phone or a completely wiped computer. But if you've cleared it with your university, right, and they were the ones that instructed you to do that, that could be helpful to you, right? To say, no, that is a compliance requirement of the university I work at. They told me I can't take certain things because of, trademark, IP risk, export controls, you name it. So that's your defense there. The other thing John said that is very important that he's correct. I ask all my clients is, okay, if you were questioned at the border, was it just by an officer wearing a badge in a uniform? Or was it by somebody wearing a polo shirt, right, with a lanyard around their neck? That indicates to me, okay, it's a higher level investigation. They were waiting for you. I've had clients say, yeah, they brought me to secondary. I was asked questions by somebody with a polo shirt from the FBI for 2 hours. All right, well, that's a really bad sign, right? That means you probably are a target of investigation.
And
Or
they
they'll
let you in,
say,
Rob. And if they let them in afterwards,
and
right?
if they let you in after the fact. Now, if you're a citizen, you're getting in regardless, right? But if you're not and they let you in, all right, we have to be careful. You're probably going to be getting a knock on your door from another friendly FBI agent who wants to talk to you or meet you at your university office and lull you into complacency. But the other issue I've seen is professors say, yeah, the interview was only an hour, but they were asking me about my papers. They asked me about this scientific paper I wrote with my postdoc in China. Okay, well, listen, if somebody from Homeland Security, the FBI, had one of your academic research papers printed out, that is a horrible sign. That means you are on their radar. We're going to potentially have some issues. And maybe I reach out to a U.S. attorney's office or your university to find out if there's been any inquiries, trying to get information on behalf of the government, either your emails or your travel or things like that. So there are a lot of different red flags that we will ask people about, and that helps us decide what their risk profile is. But as of late, I've seen more aggressiveness on behalf of CBP, but also the other agents that show up and do these secondaries, or clients who are getting their devices taken multiple times. I had one individual tell me in the past month, Rob, I've been stopped 3 times in a row, questioned for an hour or two each time, and each time they took my devices. All right, well, that's a major red flag, right? That's something I would advise everybody out there, if it happens to you once that you go through the border and they take your devices and potentially image them or don't give them back to you for a while, that's not a great sign. That means that you're most likely under investigation, or you're very close and tied to somebody who may be under investigation. One thing John said is there's billions of dollars used in this federal apparatus to build out a lot of intelligence. Obviously, when they image these phones and laptops, they don't just look at the data and dispose of it. They're building out a network of connections, and that's one of the ways people are getting dragged in.
Well, thank you so much, Robin. John. Next, we'll hear from Brian Sun, a prominent trial lawyer based in Los Angeles whose practice focuses on white-collar criminal defense and high-profile criminal investigations. Brian is a legal pioneer who defended Dr. Wen-Ho Lee, the nuclear scientist wrongly accused of espionage, with Brian leading the civil suit charging the Department of Energy with invasion of privacy, a case that ultimately settled for over $1.6 million. Brian, we want to turn over to you if you could please introduce yourself and walk us through what you're seeing on the ground, the cases coming through your door, whether the volume is climbing, and where researchers can turn for help.
Thanks, Gisela. Thanks for the opportunity to speak with everybody today. One thing I wanted to say is when I give talks like this is to put the historical perspective and keep that in mind. We all know we have challenges as an immigrant community, like many other ethnic groups, whether they're Irish, Italian, or Hispanic, or whatever. And the challenges for Asian Americans is a couple of things that predominates and manifests itself in this context with academics and researchers. And by that, I mean, I call it the loyalty factor and technology competition. Loyalty because, let's face it, anybody who's Chinese American or even Asian American falls under a little pall of suspicion. The Japanese Americans during World War II and Chinese Americans today because of the emergence of China as a world military and political and economic power. And then there's the current environment, which I would say impacts many of the people on this call, the technology rivalry competition factor between the two countries, China and the United States, which impacts the subjects we're talking about. Sort of the genesis of a lot of this focus on academics and researchers began in the 1990s when China was beginning to emerge technologically, economically, and politically. And the genesis sort of again prior to the Wen-Ho Lee case was this notion that China was maybe trying to acquire, co-op, steal U.S. technology so they could advance themselves militarily and politically. And that started in the late 90s when there was this thing called the Cox Commission, chaired by Christopher Cox from California, whose commission pretty much dove into this subject of how is China surreptitiously trying to obtain sensitive technology that could enhance China's capabilities. And during the 2000s, after Wen-Ho Lee and whatever, there are different forms of the same kind of stuff that we saw more formalized in the China Initiative. That is to say, the government, the DOJ, Department of Justice, and primarily the newly created National Security Division, which came out of 911, was focused a lot on this transfer of technology. Export controls, all those things started to get focused on by the government in terms of trying to restrict China's access to sensitive or emerging technologies. You fast forward to today, and we all know that we are in a world of AI and robotics and all these different things that are changing and shaping the world almost on a daily basis. Not a day goes by that I don't talk to one of my colleagues about the impact of AI or whether we should use it on a case or how to use it and how not to screw it up, that kind of thing. And that's what we're dealing with. And of course, the United States and China are in an intense competition in this area. And many academics and researchers either your colleagues or those of you on this call are facing this kind of issue regarding how to how to navigate through federal grants that ostensibly call for you to publish your research, but where the Chinese or foreign influence sources, I think that's the latest term of art, maybe trying to acquire some of these the technology that you're into. And so when I start talking more about what's going on in this post-China initiative environment, and I say post because during Biden they cut back on it, particularly in the criminal realm, which I thought was good. And but that doesn't mean we are out of the woods, because the administrative guys, the OIGs, as Rob and John have referred to, are the offices of Inspector General, are all over this, because the Biden administration said, you guys civilly and administratively enforce this. We'll focus on the real hard criminal stuff, the trade secret theft, the real theft of technology. Well, that has sort of carried over into the Trump administration, but with the emergence of all kinds of different technologies, we're not talking about just stuff that's like cancer drug research or stuff like biopharma stuff. We're talking about, and the first time I ever heard the words agri-terrorism, is the kind of stuff that we have to be vigilant for. And what do I mean by that? Some of you may know about the Michigan cases and others where some postdocs got charged because they were bringing in some seeds for plants or products that, for research on farm products or plant products, and they were accused of using these seeds for maybe nefarious purposes, possibly poisoning U.S. crops or something, hence the term agri-terrorism. So, and I mentioned postdocs. Postdocs are an interesting breed, one, because we get fewer of them now, because many Chinese postdocs are getting discouraged from coming over here, which I think is a big loss to the United States. Secondly, the funding is sort of becoming harder to get, because some of you are maybe on a watch list of sorts, even though there isn't one supposedly, because maybe your name surfaced during China Initiative 1, or there's just less money. And what does that mean for you folks? It may mean that the sources of funding for research, genuine research, may not come from the US government. And you now have a whole slew of private equity money that's being poured into startups, whether they be on AI, robotics, or other forms of sensitive research, and it could be biopharma, where the money's coming from private sources, but the lure is go back to China and do your research where we can do the research unfettered without US government interference. So we're seeing a trend towards more academics and researchers being recruited, lured, solicited to go back to China, give up professorships, tenure, whatever, because the possibility of taking your research to a new level is there, particularly when it's well funded, either by some local, provincial, or central Chinese government source or private equity. And AI in particular is a hot area for that sort of thing right now. But we have to be vigilant because, again, circling back to my comment about the loyalty stuff, you're going to always be under scrutiny. Not always, but you can easily be under scrutiny, not just because of the field that you are specializing in, but because of your ties to China. And that brings me to another category of case that we've seen that's been around for a number of years. More recently, in Trump 1, it became more of a deal in Biden, which is this stuff involving FARA, the Foreign Agents Registration Act. Now, some of you have read about these cases. Actually, Trump's top fundraiser, Tom Barrack, was indicted by the Biden administration for violations of the Foreign Agent Registration Act, which basically is a statute that's designed to combat foreign influence propaganda, that sort of thing. It emanates or derived from the 1930s when there was some concern about Nazi influence in the United States and big rallies that were pro-Germany in the 30s. And so FARA has now been used to focus largely on China, not exclusively. You could be charged for doing it, having connections to a foreign government other than China. But it's troubling because academics, elected officials, prominent business people who have a lot of ties or may have substantial ties with foreign governments, whether they are through universities, which are state-run universities, can be construed as a foreign government influence. You have to be vigilant for this latest species of government scrutiny. In a nutshell, if you're acting at the direction or control of a foreign government, or which could be easily someone from the local consulate asking you to do something for the government, like post a news article on a website or something like that, you could be accused of being in violation of FARA or its accompanying statute 951. And what's scary about these statutes is if you do something at the direction of an agent or you act as an agent of a foreign power, like doing a favor for a local embassy or consulate official, or maybe a professor who's tied to the Chinese government, you could be charged under FARA, which under the 951 statute of FARA, you don't have to have willfulness. I mean, you don't even have to know that you're violating the law when you fail to register with the government that you're acting for a foreign government. So it's a little scary. The government is being very selective about this, since they say, oh, we only want to go after true traditional espionage actors. But I wouldn't be surprised if an academic would be singled out one day for this kind of thing. So be careful. Following up on what Rob and John said, and you're stopped at the airport, cooperate. You've already got a name of a lawyer on your speed dial, then call it. And don't fib, don't shade stuff. Either say I'd feel more comfortable having my lawyer with me when I'm answering questions or whatever, because the government likes to play gotcha if they think you've said something that's a sort of a fib or something like that. I'll give you an example. Do you have any foreign bank accounts? And you say, well, no. And you forgot about a bank account that your mother-in-law has that you control. Okay, this is the kind of insanity we see in these cases sometimes, and you need to be very careful. So taking protective measures like talking with your university in detail about what you're doing when you do foreign travel to China, what you're going to say, vet the speech. Universities, I think, are better than they used to be during China initiative and the area, during COVID. They've gotten better, like Rob was indicating. They're going to work with you more, partly because the shift from China initiative away from indicting individual professors caused the government to start focusing on universities. So Stanford, Maryland, Ohio State, others are getting hit financially for maybe having lax compliance structures. And I think they're trying to get better, and they're not as eager to throw professors under the bus the way they used to. So these are just some general thoughts that I have about the landscape right now. We have to be vigilant. Watch what your postdocs are doing, including after they go back to China and start publishing articles. And next thing you know, you're told your name is on some article that you didn't even know was published because of your postdocs. So be vigilant. But if you take prophylactic measures, you should be fine. Be careful. It's like your health, take care of your health. Giselle, I'll stop here and
Thank you so much,
okay.
Brian. Next, our final two speakers come to us from CALDA. Clay Ju is the president of CALDA's board and managing partner of Dahong Law Offices. Clay has practiced in the U.S. for more than 25 years with deep experience in civil rights advocacy and cross-border litigation, including serving as lead counsel in the landmark 2020 lawsuit that successfully halted the federal WeChat ban. And Justin Sadowsky is CALDA's legal director, a civil rights litigator with nearly 20 years advancing constitutional protections in the federal courts. Justin leads CALDA's legal strategies, challenging racial discrimination, protecting immigrant rights, and defending civil liberties in support of Chinese American communities. Clay, Justin, we'd love to hear you share your view of the landscape, particularly on what types of fields you see being targeted, if it's only researchers in STEM or beyond.
Thank you. Good morning and good afternoon. My name is Clay Zhu, and I'm a West Coast lawyer for more than 25 years. My daytime job is run my own law firm, specializing in commercial litigation. But my part-time job right now is devoting a lot of time to this nonprofit called Chinese American Legal Defense Alliance, short for CALDA. Our main mission is to impact litigation for Chinese Americans for facing racial discrimination. We are engaging in a lot of different legal challenges at the federal and state levels. We are currently leading the legal fights in Florida and Texas for its alien land laws. And then we're also focusing on the student visa cancellation case that started last year that is still ongoing right now. Again, we are an organization that have been helping a lot of Chinese American professors and scientists. We focused on China Initiative since the day one of our organization. We're still helping several other professors today, including Professor Franklin Tao for its unlawful employment case against his former university. I think my co-panelists have already covered all the major talking points that I'm going to cover. I'm just going to supplement what I have observed. I think the landscape of the U.S. government scrutiny on the Chinese American professors have evolved dramatically. It used to be criminal heavy China Initiative. Now, it's more focusing on civil enforcements as well as some legislative expansion of other statutes, including the foreign agents statute Brian just mentioned. I think it's achieving its goal. This has not attracted so much public attention. It's quieter, but it's more effective. It has created a atmosphere of fear, and the chilling effect has been working so far. The message is very clear and loud: do not work with China. Unfortunately, this is kind of the message is being spreading out among my friends in the academic circle, all the people I talk to. They are really scared. Not only at the federal level, there are also state laws that we should be aware. Both Florida and Texas have passed state laws, including travel restrictions, as well as prohibition of employment of Chinese students, including postdoc students, visiting scholars at the public universities in Florida and Texas, as well as other red states. So this is a concerted effort to restrict how the Chinese American professors are working with professors, visiting scholars from China. There are a couple of trends here that have been already mentioned, including there's a focus on universities, mostly using the so-called False Claims Act. Basically, there's been a enforcement and examination of how universities have submitted and filled out the federal grant forms. Anytime we've seen universities being targeted, we've seen increasing pressure on the universities to asking the professors to conduct more due diligence and increase the compliance level. We've also seen the federal investigators are using AI and, of course, automated data mining tactics, just looking at any kind of published journal articles for any kind of red flags. If it's a paper acknowledging there's a U.S. federal funding, but also lists some kind of China-based research as a co-author, also dual institutional affiliations, those will raise eyebrows, and those will cause additional concerns for the federal investigators to look into more of the academic activities and the collaborations with Chinese-based institutions and scholars. We've also seen, as Rob and John mentioned, there is very much higher level increased examination of border control and immigration enforcement. We've had a lot of visa cancellation against Chinese students, researchers, visiting scholars, and so forth. Some of the decisions made at the CBP cannot be legally challenged. So there's very much that's what their discretion the statute has given to them. So lawyers, we cannot help them at all when they are at the CBP. If they're already in the United States, when the visa's being canceled, when they're being interviewed, then lawyers can play a meaningful role as far as we are concerned. We've also seen some of the risks are higher for sensitive disciplines. That includes, as a lot of my co-panelists have mentioned, AI, robotics, semiconductor, as well as material science, bio and materials, I would say agriculture science, and also plant biology. We've seen what's happening at the University of Michigan. That's just the tip of the iceberg. We've seen a lot of similar fields, and researchers have been questioned and examined in terms of how they have collaborated with the Chinese institutions. If there is any concern, they have transferred any technology to China. My final point is the one that Brian just mentioned, FARA, foreign agents. FARA and also Section 951 carries heavy criminal penalties. A lot of Chinese American people, they post news articles on WeChat, on other social media platform, some of them out of their own volition, but sometimes they talk to their friends in China, not necessarily anyone from working for Chinese government, but could be a colleague in a Chinese university, could be a classmate 20 years ago. If the message or the news posting concerns any in terms of promotion of the Chinese policies or the image of the Chinese government, it could be classified as an activity under FARA or Section 951. Those are really interesting phenomenon that is a new tool being used by federal investigators to target Chinese Americans in not only the academic field, but also elected officials, Chinese students, and also the Chinese student associations at many American universities. So my final message here is these are a concerted efforts to discourage and restrict how the U.S. based researchers and professors are going to collaborate and work with Chinese researchers. So the risks are really, really high, even though we've seen the China initiative has been kind of stopped by name, but the efforts by the federal government is definitely targeting those technology transfers. This is because U.S. and China are engaged in a high-stake competition of critical technology and industry. So as long as that geopolitical tensions are there, I think the professors that working with Chinese institutions are going to be a great concern of a target.
So So I'm going to go quickly because I want to have a conversation and we're already at 2:30. But I came to CALDA a little over a year ago. Before that, my experience was with Muslim civil rights, and I've had a lot of experience with the Federal Terrorism Watch List. And I've noticed in my year, a little over a year, a lot of parallels between sort of how the government treats Muslims and how the government treats Chinese. And I think there are some lessons from that. The first thing is, I think you've heard some of it already, is when the government takes this broad-based approach and accuses, often under the thing of national security, of these sort of crimes and puts people under investigation, it is intentionally isolating, right? One of the things they are trying to do is, by putting people under this sort of label of whether Muslim terrorist or necessarily Chinese agent, is designed to make people not want to stand up with them, to work with them, to support them. It becomes isolating. It's kind of like a virus. You said, I actually don't think that, for instance, Mr. Wu is a Chinese agent, but if I work with him or if I support him, I'm going to get targeted too. And I highly hope that one lesson you take from this is to resist that isolation, that when you see people being targeted by the government, to stand with them, to support them. Yes, there are risks in doing so, but the government's attempts to sort of scare and isolate people will fall apart if that fits. Another thing, sort of leaning against that, unfortunately, is there's a libertarian by the name of Harvey Silvergate who wrote a wonderful book called 3 Felonies a Day, which basically says that through the course of our individual day, people, particularly people who work in white collar areas, I think it's probably true in a different way for blue collar people as well, there's so much of a sort of what's criminally prohibited that you can't really go through your day without committing some sort of crime, even without knowing that you're doing so. And so when the government investigates you, the thinking is that they're investigating you to try and, because they're looking at you for espionage or a sort of specific thing, but that's not generally what they're doing. What they're generally doing is they're trying to investigate you for anything, especially if they can use the surveillance state and broad-based tactics like watch lists and the incidents of the cross-border to access your phone. They're looking for sort of anything that they can use to either accomplish their goal of convicting you for anything or trying to use you. Often we've seen in the Federal Terrorism Watch List to try and convert people into sort of spies or agents against them. It's probably also true, although I have less experience in China, right? If they have ability to sort of pressure you or target you, they might be able to push you into being sort of a spy against the Chinese. That risk is inherent, but the way you can limit your risk is some of it is just dotting every I and crossing every T. As we've heard before, always be completely transparent, disclose everything. If you might be a target, I mean, we saw in the Michigan cases, right? These people were accused of agricultural terrorism, but they were ultimately convicted. Turns out they had nothing to do with agricultural terrorism, of these sort of making false statements on a custom form about something that customs wouldn't have cared about anyway, right? That was the ultimate conviction, and then the government was able to trumpet that. We saw other sorts of situations. My understanding is that there were only 4 convictions under the original China initiative, or 8 convictions, I think 4 of Chinese people, and none of them had anything to do with espionage or trade secrets. So I think one of the questions we got is why is the government having difficulty with the trade secrets? It's they don't need to get you on trade secrets, right? They'll try and get you on anything, and so that you have to be sort of careful, and you also have to never do what you can not to talk to the FBI. Only talk to the FBI with a lawyer present. If you're, be very careful and exercise your rights. And how if you're not a U.S. citizen, as mentioned before, you might not have that many rights practically at the border. But for U.S. citizens and green card holders, you have more rights than you think you do at the border. For instance, the government can at the border. Now, if you're on a visa that can be withdrawn, it doesn't really matter what your rights are, because the government can always say, thanks for exercising your rights, we're not letting you into the country. But for U.S. citizens and green card holders, they can't. And so it's right that they can search your phone without even reasonable suspicion. But by searching your phone, it literally means physically searching your phone. And if you don't give them the password, there's not much they can do with that. Now, that's called a manual search. Now, they can, with reasonable suspicion of a cross-border crime, some crime related to the border, or that there's inadmissible information or materials on your phone, do what's called an advanced search, connected to a device. Now, there's a debate between civil rights organizations and the government whether demanding your password or physically forcing you to unlock your phone constitutes an advanced search that courts are still deciding. There's another debate that's going on right now in the District of Maryland whether being on a federal terrorism watch list specifically constitutes reasonable suspicion for an advanced search. But if you are a U.S. citizen or green card holder, remembering that they can get you on crimes you don't even know are crimes, my strong advice is to not unlock the phone for them, to hold the phone. And if you know that you're being targeted, there are tools. We often when I worked on Muslim rights would give clients who would be stopped at secondary every time they cross the border, we would give them a piece of paper, a letter written from counsel that says, we represent them. We understand that you're going to do these things. This is what our client is willing to do. This is what our client is not willing to do. And so that gives them a sort of a tool to use, even though their lawyer is not physically present with them at the border. We also have recommended either not traveling with your phone or using a burner phone. As you heard before, the government can't search what the government doesn't have access to.
Well, thank you so much, Justin and Clay. Now I'm going to turn next to what I call our lightning round questions for our roundtable of attorney speakers here. This means that I will ask a question, and I would like one of our speakers to jump on it quickly and keep their remarks to under 1 minute. And then as soon as one attorney has responded to that, I'm going to turn to the next question immediately. I want to assure that everyone will have a time to get their questions in. So first question quickly, if a professor is under investigation by the agency and the school, does quitting or retiring from the school make things a little better or not?
Not necessarily, particularly if it's the FBI or a federal criminal investigation. Resigning or even going back to China or something like that doesn't mean you'll escape scrutiny. Although if you do return to China, obviously it's be a lot harder for the criminal guys to nab you. But I don't think it necessarily ends just because you take a sabbatical or particularly if you have family in the United States and all that stuff, you're still going to have to deal with it.
Thank you so much, Brian. And keeping to the actions of the researchers, the next question is academic collaboration with foreign countries, especially China, still feasible under the current climate? How should researchers approach collaboration and working with international and intern students?
Yeah, if you're doing that, you have to work very closely with your university's compliance department. Make sure that all of it is disclosed. There are, depending on what agency your grant is from, so that's typically almost always prohibited if your grant is from NASA. They prevent bilateral cooperation. There are exceptions to that, and therefore you want to get legal advice from your university's compliance department and general counsel. But as Brian had said earlier, transparency really is the best medicine here. If you have a postdoc that goes back to China and they're still going to be doing work on research they were doing here, you need to let your university know that, preferably put it in writing, send them an email and say, hey, this is what's happening. This is the work we're working on. There may be a paper published. As I believe Clay said earlier, I've been seeing in the past month or two, some of the agencies are using AI to identify papers that have US-based researchers and China-based researchers, and then connecting the grants, and then saying, why wasn't this disclosed in an application? And then we get back to that's the type of small little error they'll try to indict somebody on. Why didn't you disclose this? And therefore allege there was a negative motive behind it. So it can be done. It is agency by agency specific. You really need to work closely with your company or your university in doing that.
Thank you, Rob. Now, what are the most common, if you could say, sort of the top 3 to 5 points of legal exposure for scholars, and what can people do to best protect themselves?
Well, I could take a stab at it real quick. I mean, look, we know from history, from prior cases that, and going back to what Rob and I have been droning on about, which is transparency helps, working with the university compliance structure, making full and complete disclosure on conflict of interest forms. Okay, you don't want to let the government play gotcha because you didn't disclose something like some $5,000 or $3,000 or even $1,000 honorarium you might have got from Beida or some school where you were asked to speak at. Okay, dot your I's, cross your T's. You can do, and I alluded to it before about the medical analogy. You can do preventive good health here by just being thorough and make disclosure. And if you have a question about disclosing something, ask about it and make a record of it. Some people who are on this call I know who did that. It really helped them out later on when we had to go reconstruct history of their state of mind when they went to China and were doing something at the behest of the university or at the invite of a foreign institution.
Thank you, Brian. And we see one registrant had submitted a question both in this chat and also prior to this webinar during registration. Under the China Initiative 1.0, 1,000 talents types of cases were a hot topic and led to a lot of scrutiny. Have any of you seen any similar issues arising under a different name? And do you see a substantive difference between the kinds of cases brought under the China Initiative 1.0 and those that are being brought now?
In terms of the first question, yeah, the Thousand Talent Program that was, spoken about quite a bit during the first China initiative. I have been in meetings with agents in the past month or two where they will point to other China-based programs that are also they are alleging are talent programs. They're not called Thousand Talent. They're maybe a scholarship program, or a local government will sponsor a postdoc or a foreign student coming to the U.S. They are looking at those, whether correctly or incorrectly, as similar to the Thousand Talent program and calling them talent programs. And again, that's something that if you're confused about the funding behind a postdoc or a program you're working on, it would make sense to dig into it a little bit and make sure you're transparent and reporting it to your institution, because the government may be looking at some of those programs as Thousand Talent like programs.
Yeah. I would just add quickly, Rob, in terms of as it relates to where we are now versus the China initiative at the actual border, I would say that it's worse today because we're seeing CBP act with more aggression. I think they're emboldened by the administration's prioritization and real emphasis on immigration enforcement. And again, the legal landscape is such that although there are, CBP does not, there's really almost no limitations on their ability to cancel a visa at the port of entry and deny someone entry and or deport them. And as I think Clay indicated earlier, it is incredibly hard, and there's just no meaningful way to challenge a CBP decision after they have canceled a visa and sent you back. So I think again, I think I'm just seeing an uptick in terms of the sheer number of people where the goal is not necessarily to further some criminal investigation, but rather just to keep someone out of the country.
I just want to add a new point here. The DoD has recently expanded a so-called a new sanction list, the Section 1260H list. At least dozens of Chinese companies and Chinese institutions and universities with some connections to the Chinese military.
Yeah.
So the definition of what is constitutes as some kind of contributor or supporter to the Chinese military has been greatly expanded. A lot of programs used to be innocent programs. For example, a program in China called Xiaojuren, a Little Giant program. A lot of startup companies in China have been received or recognized by the Little Giant program. Now it's considered part of the Chinese military complex. So that really increased the risk profile for a lot of the collaboration, and also people from returning from the U.S. to China to joining a institution or a startup companies.
I would also add, Gisela, that we should be mindful of the fact this is not just a partisan thing brought by the current administration. Some of these, enforcement measures directed at Chinese companies and Chinese universities and all that has a bipartisan flavor to it. And the House Committee, Select Committee, which many of you know is active in that. And some of those initiatives of that committee are very bipartisan in nature, and you shouldn't just ascribe it to the current administration.
No, and Brian, I'd agree. There's a lot of legislation, as you know, that's been introduced. New legislation would put further restrictions, under the guise of national security that is supported, introduced on a bipartisan basis. I agree with that.
The only thing I'll add is, people think of the government as House of Cards, and usually it's more Veep. Often when the government's targeting someone, they don't even know what they're looking for. They'll be using sort of algorithm or list-based kind of targeting, and they're just casting a wide net to see what they find. And that's happening more and more often. That's why you're seeing more aggressive stuff that's happening at the border. But the upside to that is that's less likely to be based on actual intelligence, and they're less likely to be targeting a specific crime.
And just if I may just quickly, that's what I was trying to allude to earlier. I think one of the frustrations I see is that for the CBP targeting, it is not always someone who is well-versed or his training is in those national security areas that's sending the lookout to the port of entry to pull the person in. So you have Border Patrol agents who are trained in how to detect people entering the southern border, who are now detailed to the targeting center. And at times, I think they're looking at data that the algorithm or the AI is picking up and just making decisions based on that, even though it's kind of outside their field of expertise. And so I agree a ton. And the problem is at that port of entry, though, again, there's just a lack, the challenges you face in terms of challenging the decisions of CBP, make it, allow for a lot of, unfortunately, I think there are plenty of cases where people have been denied entry into the United States, or their visa canceled, who pose no threat to the United States, no national security risk at all. But I couldn't agree with Justin more. I think a lot of times it's based on the initial targeting decision, which was ill-informed, but triggered the dominoes that led to the person being deported.
And John, following up on what you remarked on, and also in the past, I want us to step back as attorneys and look at this a bit one-on-one from the community on the ground. We received two questions that is really pointed towards highlighting what is the difference in treatment between citizens and non-citizens. With the first question asking, U.S. laws, including Bill of Rights, apply to all persons in U.S. soil, regardless of citizenship. Is this correct? For U.S. citizens, what are the pros and cons of refusing to answer questions on secondary investigations by CBP or remaining silent and waiting for counsel?
Yeah, I'll very
these
quickly,
questions, if you can walk us through.
I'll let everybody else talk about all the, issues inside the United States, but very quickly at the port of entry itself. Look, the fundamental difference is the United States cannot bar a citizen from entering the United States. And so if you are now a U.S. citizen, you're being asked all these questions, You don't face that same risk that the non-citizen faces, which is I'm going to have my visa canceled and be deported because they cannot by law deport you. And so there you can be more assertive in terms of your right to counsel and your right to remain silent without the fear of the consequences. Now, to be fair, if you're a participant in something like global entry, right, or some program like that, you're going to lose that, right? You have a negative interaction with the CBP officer, they'll take away your global entry or some of those other kind of trusted traveler programs. But in terms of your ability to enter the United States, you don't face that same risk. The good news is too, if you're a green card holder, a permanent resident, is much more CBP. Although they could potentially take you into custody and detain you on immigration related charges, they also cannot summarily deport you in the same way that you can with a visa. The unfortunate reality is everybody else, like I said, even if you have a long-term work visa like an H-1B, unfortunately, you remain incredibly vulnerable. And I think that as you're facing that questions, you have one of the reasons why you should really think about this in advance and talk to a lawyer is you just have that difficult question about how far do I want to go along with this, understanding that maybe I'm setting something up where they could potentially prosecute me later, but knowing that if I cut it off and just start refusing to answer questions, there is a very good chance they deny me entry and put me on the next plane back to wherever I came from.
Thank you, John. We have a number of scholars who are very interested in figuring out how they can reduce risk for themselves. We had an individual that asked, considering that they are in a background in STEM, in one of the quote unquote sensitive technologies, would it make a difference if they simply switched their field of study?
I mean, for me, very quickly, I think yes. I mean, look, I think the more you're related to sensitive technologies, your research is, the more you're in an area where there's tighter export control oversight. I think the greater risks are when you travel through CBP, but for the others on the other, on the people who are inside the United States as well.
Yeah, I've seen expansion, like Brian said. I represent a well-known soil researcher, right? You would have thought, I think during China Initiative 1, that would have been a focus. But I think John's right. It may reduce your risk a bit around the edges, but the other factors are who are you in connection with, right? When they, as John knows, as they build out this database to see, who's one or two steps removed from each other, maybe ran into each other at conferences, maybe has a relative in the Chinese military. I think now the way things are changing, the net is so broad that I think it's not as important if you're in the hard sciences. But again, if you're working with DoD or on semiconductors, obviously that is still on the top of the list.
Yeah, and Rob, I want to hit that very quickly. I think you make a great point. They do a lot of link analysis where they're pulling, if they're looking at the context and you're in someone's context, or they go through your context and they see that someone else is a person of interest in the context, that is absolutely a way that they will flag you. I think another thing I would say is that don't forget that the United States gets extensive data from international airlines as passenger name records. And so that is another way in which individuals are linked. Have you traveled with someone, bought a plane ticket with someone? Who bought your plane tickets? All of these are data points that CBP has access to, in addition to the ability to kind of pulse the broader holdings of the U.S. government. And so I agree with Rob, the net gets wider every day. And the technology is such now that, it's obviously with AI, the amount of data they can sort through and search, in a very short order is pretty staggering.
Even if you switch your area of focus, there's usually some reason why you're in the system. Somebody's put your name in the system for a reason. If it's just a random thing, they're asking random questions on an isolated inquiry, fine. But usually if your name is in the system, it's because your name has popped up on something. And so you're switching to something more generic like mathematics away from some other kind of area of expertise that you had may not make a difference.
Thank you all. Now, a number of our speakers have raised this topic. We have a question from a reporter asking, many Chinese researchers have been recently arrested and convicted of smuggling biological materials into the U.S., but their fellow professors claim that they pleaded guilty to end their months-long detention and return to China. What are your analysis of those convictions? And is there any recent research data to quantify the rising harassment of Chinese researchers under the China Initiative 2.0?
So I don't think that question is correct. I'm not sure if anybody's been actually convicted of smuggling uh, materials into the United States. All the convictions that I'm aware of were some sort of false statement conviction, either not including information on a customs form or making a false statement to an FBI during analysis. In most of those cases, they were charged with the higher crime. They pled to the lesser crime, often in return for, being released and, accepting deportation. Immediate deportation was sort of the consequence. So I don't accept I'm not sure the premise of the question is correct. And I would say that this is, again, what we've been talking about, right? That the government's casting this wide net and trying to get you on anything. And that doesn't necessarily mean that you're guilty of what they're accusing you of in the court of public opinion.
Yeah, they can always get you on typically a lie. A lot of people don't appreciate when you're sitting with a federal agent. If you know it's a federal agent, it's as if you're under oath, right? So that's why there's so much danger in sitting with a federal agent and answering questions outside of the basic, where are you traveling from? What were you doing there? Things like that. But once they're into, did you collaborate with this person? Did you write this paper? Did you leave this? This time that you worked at Wuhan University off your application, yes, you're in danger when they're asking questions as specific as that, and that's what they'll indict you for. It's the lie, it's the cover up, when really you were being investigated for a crime that was much harder to prove.
So the IU biology smuggling E. coli, I want to talk specifically about that one because it was presented, right? What was brought into the country was harmless and was legally to bring into the country. Smuggling is the wrong term. What they did was they failed to disclose it on their customs form.
And again, yeah, it's a material misstatement, right? Or a material omission. That's what they're getting people on. I was a federal prosecutor. That's one of the reasons, one of the things that took down organized crime, the Italian and the Irish mafia, was tax charges, not necessarily the crimes they were committing that led to them violating the tax laws. So that's an easy way for the federal government to get you.
I also want to note that Roger Innes was the professor advisor, the person who got prosecuted for that. Roger Innes spoke or sent a expert report defending the people who were prosecuted at the University of Michigan. And as a result of that, Indiana got targeted. So this is, again, that sort of attempt to isolate and big targeting. This guy ends up spending 4 months in prison because he didn't disclose something on a customs form that nobody cared about because his professor he was working with defended other Chinese people in Michigan. It should outrage everybody.
Thank you all so much. And I know we could actually do a whole panel just on that topic. I want to turn next to a question that has been asked multiple times by our registrants. It was also raised by the reporter that just had raised their question. But what are your recommendations for where people can figure out the numbers and data of the scholars, academics, or researchers, or other persons of Chinese descent who've been investigated or interrogated by the federal government, whether it's from the first iteration of the China Initiative or currently in 2026?
We'll never know that. The government's never going to disclose that. I mean, people might, using public records, be able to look at like actual indictments and convictions. And even then there'll be a question of whether it should belong or not. But investigations are going to be, exempt from FOIA. The government won't release that. Border stops will be exempt from FOIA. The government won't release that.
There's some data on the border stops that's available, and there are a few NGOs that'll track that. And I think, you could get a general sense in terms of the border stops and maybe even the border searches. I think take a look at the DHS Office of Immigration Statistics, includes some data by country of origin in terms of individuals removed at the border. It's not perfect, but it'll give you at least a general sense of how many Chinese nationals in a given fiscal year were deported at the port of entry, right, at the border. But I don't disagree with Justin. I mean, you'll never know the full scope of it all in terms of how many people were stopped, investigated, what have you. But you can at least get a sense in terms of some of the removals, how many people were actually deported when they showed up with a valid, typically with a valid visa.
And then last question for all of our panelists, and I do want to plug in ASF did do a report on the chilling effect. And so there's been study on the fear factor coming out of the China initiative, and we'll share that with all of our registrants. But I want to turn to our last question for all of our panelists, which we seem to be getting a lot of questions on risk mitigation, right? We have, for example, one individual that asked, well, what if they don't apply for federal grants and just apply for industrial grants? So a question for all our panelists, compared to when the China initiative first started, has the situation changed? Is it the same or worse? What do you think the future holds? And what can scholars, researchers, and scientists do now to mitigate their risk if there was only one thing that they could do? Start off with Robert.
Yeah, there's a lot packed in there. I think there's many investigations going on now. Like I said, I think you're seeing less indictments. As Brian said, the government's smart. They're now going after the universities, knowing they can get a pound of flesh from them. They'll pay a fine. They'll add a more robust compliance apparatus. But what I would tell most researchers now in the U.S., if you're applying for federal grants, make sure you work very, very closely with that compliance department to make sure you are reporting everything in the manner it should be reported. Don't hold anything back. And if you're concerned, if you think you're not getting good advice from your university or college or your company, reach out to an attorney. There's many of us that specialize in that. I have a whole group of lawyers who are expert in those forms and what's required and when it's required. So, but primarily work closely with the universities. They have gotten a lot better over the past 7 or 8 years.
Thank you, Rob and John.
Yeah, very quickly, I agree with everything Rob said. I think being in good standing with your university and your compliance department are critical. But I think at the end of the day, as it relates to the immigration aspects of it, unfortunately, yes, it's gotten worse. It's the tools, CBP has more powerful tools, are deploying them with greater aggression. And I think it's not an adequate answer, but either A, try to do your best from a risk mitigation perspective before you leave the United States, but B, the safest thing to do is not depart the United States. You're just so incredibly vulnerable when you go through that port of entry. If I may just say one last thing, I thought Rob made one excellent point, which is it's not at all uncommon, for a university to have a policy that you travel with blank phone or you use a temporary device when you travel to China. Certainly, I think that is a very plausible reason for why you might not have extensive data on your phone. I mean, provided it's legitimate, obviously don't lie. But when you travel, when you're returning through travel, and that might be a way to handle the electronic device issue. But at the end of the day, unfortunately, I do think the risks are greater today than they were even during the height of the China initiative. And I don't think there's a way to mitigate that entirely, except by not traveling.
And Brian?
Well, I take a little bit of an aggressive approach in the sense that I tell my guys if they want to look, back in the day, the university professors were encouraged by their institution to develop China ties. China initiative came along, then they got stomped even by their own universities for not disclosing thousand talent relationships, whatever. Now the universities are getting hammered by the government for the reasons we discussed. And, what you have is that there's more focus on them than the academics, except when, of course, they're going to China on sensitive technologies and things like that. And the only thing you can do is, besides talk to your compliance people, you can reach out to the government. You can be more on the offensive and just say, look, this is what I'm doing. You have a problem with it, let me know. And make a record. Now, that's not conventional wisdom, arguably, but if you want to be proactive on it, I have with some clients been very proactive when it comes to disclosing what, particularly in the era of startups where you have people you're collaborating with who don't care about what you know in your head. They just want to know how you're going to develop your robotics product so they can make a shit ton of money. Okay, so you can think in a way where you can cut the law enforcement guys off by being over disclosed, or tell them, look, come and look. And I guess you can't use the term open up the kimono anymore. I think that's politically incorrect, but yeah, you can do that and see what they'll do. And they may leave you alone because you You did the unorthodox thing. You came and you told them what you were doing. So that's not for everybody, by the way. So I'm just telling you that's something I consider doing sometimes.
Thank you, Brian and Clay.
Two things we've seen that's worse now than before. Oh, sorry, you said Clay.
Oh, go on, Justin.
Sorry. Two things we've seen now that's worse than before. One is the government is increasingly use of FARA, Federal Agent Registration Act, to prosecute and get people. That's a very vague, kind of difficult law to navigate that has extremely tight sort of deadlines and for registering. The other thing that we're seeing that is worse is that states are getting into the act with their own sets of restrictions, including criminal law restrictions, including baby FARA stuff. On the state stuff in particular, we don't do criminal defense work at CALDA, but we do affirmative sort of civil rights litigation, including challenging a lot of these state laws, and we do not charge for our services.
Thank you, Justin and Clay.
Just one final message. I just want to emphasize to a lot of my Chinese American fellow residents in living in this country. If you're already in this country, regardless of your visa status, you have the right to remain silent and you have the right to legal counsel. So whenever you're approached by a federal agent asking questions about what you do and how do you get to this country and what kind of association you have with a Chinese university, do not talk to them. Talk to your lawyer first. This is really important. The lawyer will help you tremendously. If you answer questions, you will be easily investigated and even charged for example, for misspoken about something that you did 10 years ago, 20 years ago. Nobody's going to remember everything that in your past life. So it is critical for you to talk to your lawyer first. Without that legal advice, you're going to easily make mistakes. And the federal government, the federal agents will get you very easily.
Thank you so much, Clay. Now we're coming up on time, and I wanted to thank our extraordinary panel, Justin, Clay, Brian, John, and Rob, for their generosity, their candor, and the work they do every single day on behalf of our communities. Before we go, a word on resources. If you or someone you know is facing this kind of scrutiny, you are not alone. The Asian American Scholar Forum is here as a resource, and we can help connect you with support. We work very closely with CALDA, the Chinese American Legal Defense Alliance, which also provides legal advocacy for our community. And as always, if you're facing a specific legal matter, please consult an attorney directly. We'll share today's recording with everyone who registered. If you found this panel and lightning round helpful, please let us know, and we're happy to do a part 2 in the future. Thank you again to our panelists and to all of you for joining us. And thank you for caring about the scientific, scholar, and research community whose work makes our country stronger. Take care, everyone. Goodbye.